All right, the second reflect we are back in session. Parties and counsel are present, all members of our jury are present. Mr. Ellington, will you continue your examination?
Mr. LaRock, as you've already mentioned, you went to lengths to attempt to show a pattern between the QuickBooks activities and phone calls to the defendant, correct?
I testified as to that pattern, yes.
And you focused specifically on check activity on the 1st, the 2nd, and the 4th, correct?
That was part of my testimony. I also testified as to records that were earlier.
And you designed that testimony and those exhibits to imply that it was Joseph that wrote those checks on the 1st and 2nd, correct?
Sustained.
Is it your implication that Joseph wrote those checks on the 1st and 2nd?
Objection, argumentative.
Sustained as argumentative and calling for speculation and conclusion.
The checks that were written that there's no computer activity for were all in lowercase, correct?
The checks from the custom account were all in lowercase.
To Charles Merritt, correct?
That's correct.
But you didn't talk about the 5th and the 8th. Who wrote the checks on the 5th and the 8th?
I have an understanding as to those, but that's information that's been given to me.
You have no forensic evidence of who wrote the checks on the 5th and the 8th, do you?
Actually, I think that the records do provide at least some context in the same way that all of the other records, to the extent that you can draw the creator of all of the checks, similar inferences can be made.
The fact that they were all paid to Charles Merritt, correct?
Charles Merritt and Metro Sheet Metal Company.
And all the ones to Charles Merritt were negotiated by Charles Merritt, correct?
Objection, foundation.
Sustained.
Well, I'm sorry. Bottom line is you reached your conclusions without considering Dan Kavanaugh's cell records, correct?
The conclusions
I'm
as...
sorry.
Objection, cumulative.
Sustained.
You did not consider the defendant's cell records.
Objection, cumulative.
Sustained.
You did not consider the defendant or Dan Kavanaugh's spending activity in Hawaii.
Same objection.
Sustained.
You did not consider the PayPal transactions of the victim.
Same objection.
Sustained.
You didn't even testify to who wrote the checks on the 5th and the 8th or the forensic evidence of it.
Objection.
Did you?
Cumulative.
The objection sustained as that would be calling for speculation and conclusion.
Which device did you find evidence of the checks being written to Charles Merritt were created on? Which device?
Objection, cumulative. The court's admonished him. I mean, the court has already sustained objections. We'd ask for an admonishment.
Sustained is cumulative.
Give me a second while I pull up one of your exhibits. Showing you what's been marked as your, well, as exhibit Joseph's phone records. you had it as 7D, remember those?
I do.
That is the court's exhibit number 1045. From 12:15 to, wow. Let's say 4:13. You see all those IP addresses logged?
Yes, I do.
Did you run those?
These particular ones, no. I did run some of the IP addresses from this to try to gather information. I did not see enough information to explain what the IP addresses, assuming those are IP addresses, mean. I didn't find sufficient information in this report to show what an IP address, if that's what that is in here, means.
And I would object to assume facts, not evidence, because those numbers were not identified by the expert.
Overruled.
Same format as an IP address, correct?
That's right.
Did you even make an attempt to verify that's an IP address?
Objection relevant.
Sustained.
Well, you made a point yesterday to talk about Joseph McStay's activity on the 4th, correct?
I testified as to the records indicating his activity on the 4th, yes.
Because when you created this exhibit, you even intentionally highlighted certain things, correct?
Yes, that's right.
But you didn't look into whether these are IP addresses or what Joe was doing at that time?
Objection asked and answered.
Sustained is cumulative and argumentative.
So, when it comes down to it, as you wrote in your report, based on your investigation, it is difficult to draw any conclusions.
Objection
Fair to
asked
say?
and answered.
Overruled and answered, yes.
That's what you wrote, correct?
Can you give me the context of that, please?
That was your conclusion of your findings in your report. Quote, it is difficult to draw any conclusions, correct?
Yes, I believe I did write that.
Nothing
in
further?
the context
Nothing
of,
further?
You can explain yours.
I object, there's no question pending, Your Honor.
You can explain yours answer.
in the context of all of the information which I gave in my report before that point, which explains many of the things that I testified to, I felt, after analyzing all of the evidence, that it was difficult to draw specific conclusions as to what happened to McStay's on the evening, if there was a reason that they had disappeared, and from the electronic evidence that I had examined, whether there were specific conclusions I could make as to who murdered them. My overall conclusion after reviewing everything was simply that, though I did find findings which I testified to, I could not make any specific conclusions as to those overarching questions.
In terms of the forensic evidence, not the subjective interpretation of it, correct?
Again, I disagree with the term subjective. Throughout all of my examination, I was relying upon evidence and showing the interconnections of evidence and suggesting what seemed my expert opinion as to what those connections could be and what they could mean, because that's my job. So when examining the various pieces in here, I did come to certain conclusions about each piece of evidence, but it was difficult or impossible to draw final conclusions to the grand overarching question as to what happened to the McStays.
I have nothing further.
Standing on redirect.
Thank you. I want to talk about the ledgers from 2007 to 2009. Do you recall that line of questioning?
Yes, I do.
And counsel had introduced a new document, and that was an email. And I believe it was exhibit 419, dated February 1st. Do you recall that?
Yes, I recall the email.
Okay. And I think he posted on the overhead, and you looked at it, is that correct?
Yes.
When you saw that document, did that show any significance to you in regards to the 2007, 2008, and 2009 logs, or the ledger those ledgers that you found?
Objection,
Yes.
not relevant.
Overruled, answer me.
Yes, specifically there was a lot of similarity between the box at the bottom right-hand corner that we were speaking about in the 2009 ledger in comparison with the data that was in this email.
Okay, so when he showed you 2007 and 2008, as far as Joseph's ledger had zeroed out each of those years, and there may have been a discrepancy of $200 or something of that nature. Is that correct?
From the upper part of the ledger, that's correct.
Okay, but essentially it had zeroed out the account between Joseph and Mr. Merritt, correct?
Objection, misstates his testimony.
Overruled, answer.
Looking at that top part, yes, the overall balance appears from that to be approximately zero or very close to it.
And I think you indicated that the 2009 ledgers, especially the first one, was incomplete. Is that correct?
Yes,
And then, but you were later able to find it on Google Drive, correct?
that's right.
And that was more complete, but not entirely complete, correct?
That's
Objection
right.
calls for speculation as to completeness.
Overruled.
It had significantly more information. It's still, the top part still didn't list out all of the transactional payments to Chase Merritt. However, there was a lot more information in this particular ledger.
All right, I'm going to go to page 3 of that, and I'm also going to do a split screen with that February 1st email from Joseph to Chase and that's exhibit 419. So we're going to put up a split screen of that, and if you can just indicate for the jury what the significance of that email is.
And for the record, it's exhibit 1033 and 419. We can have exhibit my computer.
If we can, and if you can use the pointer to help out, yes.
Sure. Okay. So let's see here. I'm trying to figure out the correct best order of saying this. Okay, so first off we were looking at, actually can you scroll up just a little bit in this one? Okay, so first off, when we're looking at this one, we started off by looking at these things that show overpaid entries, and we totaled it up, and it says 173,000 here. Looking over here at the email from Joseph McStay to Chase Merritt, you see an entry here that says Chase paid 173,000, the same number, 255. And then it says immediately down below that Chase owed 158,210, and then overpaid 15,045, and just immediately above that this says as of 2/1/10, presumably February 1st, 2010, which is the date of this email.
And are those numbers that you just identified, are they in that box that was on the 2009 ledger?
Let's see here. So we've got the 173,000 here.
if you keep going down,
The 158,210 is down here, and then finally overpaid 15,045.
so those numbers that Joseph had on the 2009 ledger are identical to the email he sent to Chase on Exhibit 419, is that correct?
Correct, which was sent on February 1st.
And essentially, at least up until that point, it shows an overpayment, meaning he's overpaid Chase, at least as of February 1st, correct? Of $15,045, correct?
That's what it looks like based on total paid, Chase owed, and overpaid.
And that matches the email, correct?
That's right.
Okay, now, counsel forgot to mention the line up above when he talked to you about that. Can you explain what the number of 26,000 represents just above that, the February 1st date?
I'm sorry, I was actually looking at something else in the beginning of the question. Could you ask
Sure.
it again?
Sure. It says as of 2/1/10. Just above that, counsel, when he went over that with you, he left that out. So I want you to take a look at that and what, if you could, what does that represent?
Objection calls for a conclusion, calls for hearsay, calls for
Well, we
speculation.
can answer if he hasn't.
I see PM, 15% number savings, another number, a similar line for SA. I definitely know from my work on this case that
Objection calls for hearsay.
Overruled.
that Chase and Joseph were working on, were doing work for Paul Mitchell, and they were also doing work that they referred to as Saudi Arabia,
Okay.
relative to the time of this. So it's, though I certainly don't know for sure, that appears to be consistent with other work and conversations that they had.
Objection, speculation, move to strike.
Overruled.
Does that also, that 26,000 also consistent based on your review of the forensic records in this case and the logs that we've just been talking about, that 15% plus the additional amounts there, which totals 26,000 for the two jobs, is that consistent with the commissions that are due, still due to Mr. Merritt on those two jobs?
Objection exceeds his foundation, calls for speculation.
Sustained, assumes facts not evidence.
15,000. If we added the 26,000 to that figure where Joseph leaves off as an overpayment, if we took the 26,000 and added that to the overpayment, we would have an amount owing to Chase of 11,000. Is that correct?
Objection calls for speculation as to O2.
Now, this document, this email, this document was a document that when you reviewed it, you actually forwarded it to the forensic accountant. Is that correct?
Actually, it was the other way around. I received this from the forensic accountant.
Okay. And so, and who was that forwarded it to you?
I'm sorry, I forget his name. I know the accountant's name is Dennis. I want to say, I believe
Sjogren?
It was I don't think it was Dennis. I think it was another.
Eric?
That sounds right.
Okay.
Eric Sjogren.
Okay. And so, they were familiar where those numbers came from, is that correct?
Objection calls for speculation and hearsay.
Okay. And on the logs, the when Provecho is talked about, going back to 2008, and that would be figure out what number that is.
2008 is 1029.
Is it? 1029. Okay, 1029.
Just 2008.
What Provecho is talked about on page 3, I think it's, yeah, right, no, down, yes. Is it consistent that Joseph refers to the Provecho as a disaster?
Consistent with what, I'm sorry?
Is that how Joseph is referring to Provecho when you review these records as a disaster?
I see Provecho disaster throughout the records.
Okay. And do you know why did you find anything in the records why he was referring to it as a disaster?
Objection calls for hearsay.
Sustained is calling for speculation and conclusion.
It's just asking for a yes or no, Your Honor.
Objection sustained.
And before we took our break, you were in the middle of an answer, and I believe you were explaining the question. Do you recall what that was?
Before this last break?
Yes.
The question was whether I did any investigation into whether or not Dan Kavanaugh would have used a VPN for the connections in question.
Right. And I think the question was, did you do anything other than look at the IP addresses? Is that correct?
Objection misstates the testimony, and also the court has already sustained an objection to this line of questioning.
Well, how did you understand the question, and what were you attempting to explain?
So, sorry, this is to explain this. I have instructions, I believe, from the court as to what I can and cannot say here. So I'm trying to follow those instructions.
I'm gonna object to move to strike. Non-responsive.
So you, number one, did you do any kind of an investigation into whether or not Dan Kavanaugh was using a VPN?
Yes, I did.
Okay, tell us generally what you did in that regard without going into the contents of any materials that you looked at.
I tried to think of what I could do, what I could examine to answer that question. It's a very difficult question to answer. I looked at two main things. I looked at the consistency of the logs and the locations and the context of when those IP addresses with those locations were used. And then I also looked at interviews with Dan Kavanaugh that gave information that was relevant to me.
And did you ultimately come to a conclusion?
I found more information that was useful for that. I don't know that I can say that I came to a definitive conclusion, but I definitely found evidence that would support not using a VPN.
Okay.
Thank you. I'm going to go to the activity logs that counsel showed you of Dan Kavanaugh, which has the IP addresses. Do you recall which exhibit I'm talking about?
Yes, I do.
Okay. Is that 10D?
That's 10D, correct?
And on the back?
I don't have the exhibit, I only have my copy.
Okay.
Is
And it,
exhibit 1055.
55?
1055. So if we could go to page 12 of 12. So if we go to the January 14th date that I asked you about on direct, okay?
Correct.
If you could explain what is significant about this to support your opinion that a VPN was not used.
So this is offering evidence that would certainly not confirm, but suggest that a VPN would not have been used, simply because we see the Daniel Kavanaugh at gmail.com login on January 14th, and this is coming from an IP address with a location listed in Hawaii. The very next one that we see of January 26th, and so the very next one we see January 26th is coming from an IP address that is listed among all three of these, which adds to the confirmation of it as San Diego, California. And then for consistency, we see that going on up forward from here for quite some time, the same IP address of San Diego is used. And then of course going on forward from here, we just see consistency of San Diego, Southern California, San Diego area IP addresses. So the evidence that we're looking at here, it shows an inconsistency of a first single login from Hawaii as opposed to all of the other IP addresses which are listing San Diego.
In other words, if a person is in Hawaii and they're going to access PayPal, they access PayPal and they have an IP address reflective of the location of Hawaii.
The 66.91.7.2.
There's no VPN, correct?
Objection calls for speculation.
Well, you can't say yes.
If the person is in Hawaii, there would be logically no VPN being used, correct?
Objection calls for speculation.
Actually, let me rephrase that question. There would be no VPN to a San Diego location. If the person is actually in Hawaii and they register an IP address in Hawaii, there's no VPN in San Diego. Is that correct?
This is consistent with accessing the PayPal account simply from Hawaii. There would be no, for it to have anything to do with San Diego, it would have to be something that would go from Hawaii to San Diego back to Hawaii, which doesn't make sense for these records.
Okay. Does that also go to your to support your opinion that no VPN was used?
That information supports the idea that no VPN was used.
So on January 26th, if that person was still in Hawaii, they didn't use a VPN before, does that also support, and then obviously they're not using one on the 26th because they didn't use it on the 14th when they accessed PayPal.
Objection assumes facts on evidence, calls for speculation.
All right. Now, counsel didn't do an experiment on, he took some random date or whatever, but he didn't want to do his experiment on January 14th.
Objection argumentative.
Did you checked these IP addresses on your own? Is that correct? When you ran it through the services?
Yes, that's right.
Okay.
I checked everyone.
And even before you testified, you checked again?
Yes, I checked on multiple times. Yeah.
And as you noted, going up on the dates, even on this page and even on subsequent pages, the accuracy was visible to you as to the IP locations?
Objection leading and assumes facts not evidence.
I did see a consistency that clearly showed San Diego and/or the San Diego location, Southern California areas.
Counsel asked you about some questions about whether or not you knew Joseph's state of mind and what factors you took into consideration or didn't take into consideration to determine his state of mind. And he was referring to a time period in 2009. Do you recall that line of questioning?
Objection misstates the testimony.
Well, the witness remembers it.
The objection sustained on relevancy and evidence code 352.
Do you remember counsel's questions regarding Joseph's state of mind in 2009?
Objection.
Sustained.
Now, counsel asked you about whether or not you checked Joseph's IP addresses and other documents when it came to the issue of looking at Daniel Kavanaugh's IP addresses. Do you recall him asking you that, whether you considered Joseph's?
I do.
Okay. The question that was posed to you was, and you said you took your direction, I think, from either myself or someone from either myself or Mr. McGee, in regards to why in the world would you be checking the Daniel Kavanaugh IP addresses? And do you recall getting direction from us on that question?
Objection misstates the question that was posed in the responding testimony.
Overruled, answer yes or no.
I don't recall the exact question. I remember the line of questions about that.
And it had to do with Daniel Kavanaugh's supposed alibi of being in Hawaii. Do you recall that?
Objection
correct.
assumes facts, not evidence.
Sustained.
You were checking Daniel Kavanaugh's IP address for a reason, correct?
Yes, I was.
What reason was that?
I was trying to ascertain whether there was evidence to show if Dan Kavanaugh was in fact in Hawaii at the time that he says he was in Hawaii.
In the spirit of thoroughness, did you consider some other things as well? Let me ask you this. In the spirit of thoroughness, was the defense the only one concerned about this supposed alibi?
Objection calls for
Of Daniel
speculation
Kavanaugh.
and irrelevance.
Sustained. Calling for speculation.
Did you consider any other materials as to the issue of whether or not Mr. Kavanaugh was in Hawaii?
Quite a lot of materials, yes.
Okay. What about materials from law enforcement themselves?
Yes, I did.
Can you, what specifically?
Objection hearsay. Relevance at this point, beyond the scope.
Overruled, you can state what documents you may have referred to, but not the contents of the documents.
I found evidence related to this in an interview with Dan Kavanaugh by a law enforcement agent, by detective, I believe.
Okay. And what about any search warrants?
I did see a search warrant. Yes, I did see a search warrant related to Dan Kavanaugh.
And when counsel was asking you about questions about that issue, did he bring up anything about what law enforcement thought about the alibi?
Objection argumentative and misstates the testimony.
Now, the calls that I went over with you when there was a transaction with QuickBooks, a check being written, a check being deleted on February 1st, February 2nd, February 4th. Do you recall I went through that with you?
Yes.
And each time after a check was written or deleted, there was a phone call either from Joseph McStay to Chase or Chase to Joseph. Do you recall that?
There were both of those. In particular, I noticed phone calls from Joseph to Merritt, and then there were some instances where of calls the other direction too. Yes.
Okay. Now, and counsel began to ask you about subsequent checks on the 5th, the 8th. Do you recall that?
Yes.
Okay. Were you in a position, or did you look at those records as well to see after check activity was done on QuickBooks on the 5th and the 8th, whether there was calls was there a call from Mr. Merritt to Joseph's phone?
Objection, beyond the scope, court sustained objections.
Counsel showed you a exhibit 414. It was basically something that said Dan, and then it said Hawaii, and it was a call of some sort with a phone number. Do you recall that, exhibit 414?
Can I see it?
Yeah, I'm going to show you the whole thing since only part of it was put on the screen. If you could take a look at the page that was shown to you on the overhead.
I recall.
Okay. Do you know what that document is now, after you get a chance to look at the whole thing?
I still have very little information as to what this document is. I believe, apologize, I forget your last name. I believe it was identified to me as a helpline or
A call to the sheriff's department for a welfare check?
That's it, thank you, yes.
Okay, and it indicates there that it says the caller, identifies the caller on that, is that correct?
Yes.
Okay, and it says, if we go to that page on the screen.
Page 3?
Yeah, there we go. It says Daniel Kavanaugh, and then it gives a phone number, right?
That's right.
And it says address Hawaii.
Yes.
So the way you understand this now is it's a call from a caller identifying themselves as Dan Kavanaugh, right?
Objection, speculation.
Sustained.
And if it's a call from a caller to the sheriff's department, the caller is the person giving the sheriff's department the information, correct?
Objection lacks foundation, calls for speculation.
Sustained.
Okay. And did counsel provide, or did you see in discovery, any recording of that call?
I did not see in discovery a recording of this call.
Okay. Nothing further, thank you.
Anything else, Mr. Ryan?
In looking into the whole Dan Kavanaugh issue at the direction of defense counsel, where you provided the interview of his girlfriend, Lauren Knowles.
I don't believe I've seen an interview with Lauren Knowles.
Nothing further.
Anything else?
Did you, since you've been following this trial, do you know if the people have called Lauren Knowles as a
Objection
witness?
argumentative beyond the scope.
Sustained.
Do you know if the people have called Daniel Kavanaugh as a witness?
Objection argumentative beyond the scope.
Nothing further.
Anything else?
No, Your Honor.
Any objections to Mr. Lolock being excused?
Subject to recall, please.
Sure. Thank you, Mr. Lolock, for your attendance. You are excused. I assume they know where to find you if we need anything additional. Make sure you don't take any of our exhibits with you. Otherwise, you will be coming back.
Can you give me one moment just to, this should be all my copies, but I'd like to double check that.
Sure. And it's about 4 o'clock, so we'll go ahead and take Our evening recess is time till 9:30 Monday morning. Keep in mind the admonitions previously given to you, not to form or express any opinions about the case, not to discuss the case or allow anyone to discuss the case with you or in your presence. Again, that means not discussing anything about the case, any of the witnesses, testimony, exhibits, parties, or attorneys, and we'll see everyone back Monday morning. Have a good weekend. All of the jurors who've left, counsel and parties are still present. Counsel, wanted to address something?
Yes, in an attempt to relitigate, just make sure the record is clear of our argument or objection. We ask that the expert be allowed to explain his answer on cross before the break. The people cited the Malik case, M-A-L-I-K. Defense has reviewed that case. That case says that it'd be a confrontation violation for the prosecution to use hearsay statements to impeach a defense expert's opinion. And they said since the witness was not actually called who will present that evidence, that is hearsay evidence that should not have been allowed in. It's not to say the expert cannot present hearsay evidence that he relied upon for a statement when questioned by an adverse witness. So we just want to make it clear that we believe defense was not, expert was not given the proper opportunity to explain his answer.
However, the Sanchez analysis is a twofold analysis. For the record, a hearsay evidence code issue and a Crawford issue. Obviously, the people have no standing to use Crawford in that sense. So clearly, it's an evidence code analysis, and that, under the Sanchez rule, still stands, whether it's on cross or direct.
Court's ruling remains the same. For the same reasons. Have a good weekend, everybody.
Bye.